Good morning.
Morning, Your Honor. I represent Marcus D'Amicus. He's appealing the denial of his motion to waive entry fees by a single justice of the appeals court on the grounds that, first of all, it's our contention that this is a quasi-criminal matter, and secondly, it's our contention that the procedures laid out in Chapter 261 of the general laws do not apply in this type of procedure, and there's an alternate procedure, as this court held in the Hunt case, to proceed under Rule 12 and move to waive entry fees under Rule 12.
So in that way, you are able to avoid, and I don't mean that in a bad way, the fact that he's got $1,700 in his account?
Well, the definition of indigency under Rule 12, I suggest, is similar to the definition that exists in the federal courts on federal habeas corpus. The federal courts have held that the defendant has a constitutional due process right to have all his federal claims heard, a fair hearing on all his federal claims in the state courts. And if he doesn't get a hearing in the state courts, he has a right then to go into the federal courts on federal habeas corpus and get that hearing.
But if this is just for the moment, taking hypothetically Rule 12 out of the picture, right, he'd be a dead duck because he's got that $1,700.
If, well, that would be true of a criminal defendant under the Commonwealth's logic also, because
he could pay the fee.
But isn't your point, though, that this doesn't fit under 27B? This is not commencing, or 27D, actually. It's not under 27D.
Chapter 271 is not mandatory. A person doesn't have to file for a waiver of fees under Chapter 261, because Chapter 261 specifically provides that he may file for a waiver of fees, not that he must file under that particular statute.
Okay, my question really was this. Under 261-29, it appears to be saying that it applies if an inmate brings an action. Now, this is an appeal from an adjudication that your client was a sexually dangerous person, right?
Right.
So he's
Yes.
not bringing an action.
No, he's not bringing an action. He's taking
so
an appeal.
So you would argue 29 and all its things about the prison.
But it wasn't meant to apply to this type of situation.
It's not a question whether it was meant to.
Right.
I mean, wasn't 29 enacted? Isn't the legislative history that Section 29 of 261 was because there was a concern that people who are incarcerated, serving lengthy sentences, bring claims of, access to facilities, violations of due process, and so on. Isn't that what we're dealing about?
Yes, that's quite true.
That is different from taking an appeal
Yes.
that the Commonwealth has commenced.
Yes, I suggest that's quite true. And the United States Supreme Court, I'd suggest, has made this distinction. They say that in the ordinary civil case, a person has no right to proceed, a constitutional right to proceed in forma pauperis. In the ordinary civil case,
But this is
not the ordinary civil case.
Well, it's not. The issue of whether it's civil or criminal really doesn't arise in this sense. If your client had commenced an action saying that he had some problem in the proceedings,
right.
5 years later, then we might have to address, correct, whether or not it was quasi-criminal, criminal, civil, sufficient for purposes of 261, and then you trigger the United States jurisprudence. But this is not a commencement of an action.
No, this is quite true. This is an appeal.
And if the answer to that question is, it is not a commencement of an action, that's the end of the case, isn't it?
Well, I'd suggest that's true, and that's the way it should be interpreted, because this, I'd suggest, first of all, this is under the decision of the United States Supreme Court, this is a quasi-criminal matter.
No. As a matter of Massachusetts state law.
Statutory interpretation.
Yes, I'd suggest as a matter of statutory interpretation, it should be interpreted so that we can proceed under Rule 12, and we do not have to proceed under Chapter 261. In fact, I'd suggest that's what the Hunt case said. I'd suggest also that under the United States Constitution, this is a quasi-criminal matter, and therefore the same rules that apply in appeals from criminal cases apply to this case.
Which is what, Mr. Skeels?
Well,
No fee is permitted at all?
The person has a constitutional right to proceed in forma pauperis. In the normal civil case, a person doesn't have a constitutional right to proceed in forma pauperis.
But who defines that? Doesn't state statute decide what in forma pauperis is?
No, the United States Supreme Court says that in a quasi-criminal matter,
Yeah.
the Constitution applies. And, of course, the definition of indigency that the federal courts apply is not the same that the definition that's included in Chapter 261. The definition of indigency on the federal courts on habeas corpus would be similar to Rule 12.
So we accept the federal indigency standard for determining whether someone can proceed in forma pauperis?
Well, I suggest that the standard for proceeding in a quasi-criminal case should be the same as the standard which applies in the federal courts on federal habeas corpus.
Oh, well, you're in pretty good shape. If you put the statute aside, 261 so forth, then you get into Rule 12, as I understand this.
Yes.
And clearly $1,700, you're indigent. Right?
Well, I would suggest he certainly he would be under that situation.
I mean, that's all he's got, isn't it?
That's all he has, and the problem here is that he doesn't feel, I suppose, that probably that, and like a lot of people, that he probably doesn't have much of a chance on appeal, and he doesn't want to spend what little money he has left in order to take this appeal. This is the problem. This is why prior to 1960 there were only perhaps 10 criminal appeals.
On the other hand, an argument can be made that he isn't indigent because all his expenses and needs are covered by the Commonwealth. Are they or are they not? He's serving time.
Well, he has to pay for certain things at the institution. This is, I suppose, why the inmates have accounts, so they can pay for their fees for things at the institution.
Mr. Skeels, what do you say, forget 27D for a minute, but I think it also applies under 27B. What do you say to the fact that the appeal from Judge Duffley's ruling was not brought within 7 days?
Well, I think we mentioned this in our reply brief. First of all, Chapter 27, that particular statute, by its very terms, does not allow an appeal from a single justice ruling. In fact, in the Hunt case, this court held that you have to take an appeal under, I think it's Rule 15, and the 7-day rule doesn't apply to
Okay.
that.
All right.
Secondly, we're arguing here, we're proceeding under Rule 12 rather than under Chapter 260.
So would that also answer the question that the appeal should have gone to, is timely, but should have gone to a panel of the appeals court?
Well,
Didn't
yes.
Why didn't it go to a panel of the appeals court?
Well, we asked for direct appeal appellate review.
No, you did, but one reason we might turn it down is you haven't gone where you should have gone in the first place.
Well,
which
we
is
weren't
a
allowed to because the single justice denied our motion to
waive the fees.
for the fees.
And under Rule 12, that goes where?
Well, it normally,
We appealed to the
would-
appeals court,
it would normally,
and
Oh, you did. You appealed to a
yes, we
panel,
appealed
and
to
then
the
we
appeals
took
court.
it. Okay, that's fine. Now, this Clark case doesn't seem to add much anything to either side. This was purely a technicality on which he
well,
lost.
it had a very practical effect in this case. We filed a motion for free transcript in the Superior Court, and that was allowed. There was no problem. But then when we got to the appeals court, the Clark case had been decided after we'd gotten the free transcript.
Yeah.
And then we weren't able to get a waiver of entry fees in the appeals court because of the Clark case. That was the problem that we ran into in this case. And that, of course, means in the future, in other cases, we'll have a problem getting free transcripts and problem getting any kind of waiver of fees in this type of case.
Mr. Skeels, let's assume for a moment that we conclude that the statute, which has got some reasonably broad language, talks about commencing an appeal,
Right.
if that's possible, applies. Your client has enough money to pay for the entry fee, so what's the constitutional problem here?
Well, the constitutional problem is, I suggest, he has a right, because it's a quasi-criminal matter, to proceed under forma pauperis, under Rule 12, rather than under this 261. Under the MLB case, because it's a quasi-criminal matter, the same rules apply that apply in criminal cases. Now, the problem is, of course, if this procedure is applicable to people in this position, it's also applicable to people in the criminal matters. Our concern here is that under the government's logic, 261 applies to all inmates. Well, inmates are defined by the statute as including anyone in a state or county correctional institution. And 261 applies to criminal and civil matters. So if the government's logic is correct, then anyone taking an appeal from a criminal case who's been committed to a state or county house of correctional facility must also comply with Chapter 261. We have a rule of court, Rule 10, that says that all fees are to be waived in criminal cases. However, under the Commonwealth's logic, the statute trumps the rule of court, and therefore all criminal defendants would also have to apply with the provisions of Chapter 261.
27B specifically states upon appeal in a criminal case. 27B on its face seems to me would apply to criminal
Would apply to,
defendants.
that's the problem. If this
But
logic...
but the rule then
if this-
says there won't be a fee.
Well, but the Commonwealth says that the statute trumps Rule 12. If it trumps Rule 12, then presumably also trumps Rule 10, and criminal defendants have no right to proceed by filing a motion under Rule 12 or under Rule 10. This is our concern. This logic can now be applied to criminal cases. And the United States Supreme Court has said there's no constitutional difference between a quasi-criminal matter and a criminal matter. If this is constitutional for quasi-criminal matters, then it's also constitutional for criminal matters. And the same type of, and I'd suggest under the Rinaldi case we cited in our brief, it would be unconstitutional for criminal matters. That this procedure, I suggest, does not comply with the holding of the United States Supreme Court that in quasi-criminal matters, a person has a constitutional right to proceed in forma pauperis. And the rational basis test, which applies to most civil matters in determining whether such fees are constitutional, has no application to this type of case or to criminal cases. And this is the reason that Rule 10 provides for persons in criminal cases to have their fees waived. And it is the reason why Rule 12 allows a judge in a civil case to allow someone to proceed in forma pauperis.
Does the Supreme Court say that that the rules regarding proceeding in forma pauperis mean that the person appealing is entitled to appeal free of charge, or can the state set reasonable standards as to how much money the person should contribute?
Well, I think they said in the MLB case that I'm considering, they said that when it comes to quasi-criminal matters, the rational basis test has no application to that type of situation. We don't consider whether or not these fees are reasonable in determining whether the fees that have been set are constitutional. That test has no application.
So under the Supreme Court cases, the state could not charge all people $1 to file a criminal appeal.
Well, it might be able to. I'm not saying that is necessarily true. However, I think in the Rinaldi case, a similar situation where they said that a criminal defendant had to pay for the appeal out of his inmate account, that procedure was unconstitutional.
Could the state charge under 27B, which has a proceeding for
Right.
having an affidavit of indigency, if Bill Gates were to file, could the state charge Bill Gates to bring a criminal appeal?
Well, under Rule 10, he wouldn't have to. He wouldn't be
Constitutionally, you're saying this is a constitutional. Could the state do that constitutionally?
Constitutionally. I think it does require some payment of fees.
So can't the state therefore constitutionally do some kind of individualized determination whether X defendant can or cannot pay a fee?
Well, that if it did, then that particular fee would not be tested as to whether it's reasonable under the rational
No, it would be
basis.
whether this defendant could pay it.
It would have to be tested under the same test as in NLB, and I'd suggest there would be serious problems in that case.
Thank you, Mr. Skeels. Mr. Hallaz?
Good morning, Your Honors. My name is Benjamin Hallis. I'm a Special Assistant District Attorney from Middlesex. This court lacks jurisdiction to hear this case because the respondent failed to file his notice of appeal within 7 days of the order denying his request for a waiver, as was required by General Laws, Chapter 261, Section 27D.
Yeah, but he says that statute doesn't apply. So if that statute doesn't apply, then the 7-day rule, we don't even need to consider it.
Yeah, I mean, yes, Your Honor. Well, dividing sections from statutes, Chapter 261 has two different provisions that are at issue here. So if the court were to find that the entirety of Section 261 does not apply, then yes, Your Honor, you would be correct. However, the respondent's argument that the arguments, constitutional arguments, and the arguments about the fee waiver procedure rise and fall with the arguments about the appeal procedure is incorrect. These are two different issues. One issue is whether Section 27D or Rule 4 applies, whereas the other issue is whether the procedure of Sections 27A through 29 or Rule 10 and 12 apply.
I read 27D, but I don't see anything that relates to appeals arising in the appeals court or appeals arising before the single justice.
Well, Your Honors, it states that in any case where a court denies a request for a waiver of fees and costs pursuant to Section 27C or any other provision of law, the plain meaning of that language is that it applies to all cases. That would include cases on appeals. Additionally, Section 27B clarifies that overall the provisions of Section 261 control all cases, including appeals. Since the deadline is set by statute, it cannot be waived by this court, as stated both by the Clark case and the Friedman case. The respondents claim that he's filing under the rules of appellate procedures without merit for several reasons. First, the statutory deadline is more specific. It applies to fee waivers specifically, as said in Section 27D, and it applies to appeals, as stated in Section 27B. Additionally, the rules provide that they do not modify statutory deadlines, and the respondent's interpretation that he gives would not make sense, since he argues that the party should have the option of deciding when would it wish to file under the rules of appellate procedure and when it wished to file under a mandatory deadline set by statute. For this provision, the respondent relies on the Hunt case. However, the Hunt did not state that Section 27D could be ignored, as the respondent claims. Rather, it stated the rules in the statute should be read in conjunction. Where there's a gap in the statute, as there was in Hunt, the rules can help fill in that gap in the statute. However, here there is no gap in the statute. Section 27D is explicit. It applies in all cases, and in all cases the notice of appeal must be filed within 7 days. The respondent claims in his reply brief that the Commonwealth's argument proves too much, and that under the Commonwealth's reasoning, criminal defendants also must apply for waivers because they are inmates. However, this isn't true simply because criminal defendants do not face a fee on appeals. Therefore, there is nothing to be waived. However, where a party does seek a waiver of a fee, it must comply with the procedure, the appellate procedure.
But the only reason they don't have fees on appeal is because of Rule 10. It's not because the statute would suggest that they should have a fee, doesn't it?
Your Honor,
27B?
I would disagree, Your Honor, in the sense that the statute provides that where there is a fee and someone is an inmate, well, again, there's two different sections of the statute. Section 27D applies on appeals, and the rest of the statute applies where someone is an inmate and seeks the waiver of costs. Therefore, if there were no fee, then the respondent wouldn't have anything to waive, and he wouldn't have to go through this procedure.
I realize that, you know, there are lots of statutory provisions here, and one of the problems is we've had some additions. The 27C says if the affidavit is filed with a complaint or other paper initiating the proceeding, and then 27D kicks into, you know, where the court denies the request as provided under 27C. The fundamental difficulty that I'm having here is so much of the statute seems to be driven by when when an inmate or somebody else is initiating a proceeding, and you're saying an appeal is initiating a proceeding. Now, I understand that there are some cases, for example, where maybe a divorce, child support, but a criminal appeal doesn't seem, an appeal from a case which is criminal or quasi-criminal doesn't seem to me to be initiating a proceeding. Isn't that the fundamental crux
No,
here?
but Section 27D, if you read the rest of it, it says, in any case where the court denies a request for waiver, et cetera, pursuant to Section 27C, that would suggest beginning a case. But then it says, or any other provision of law.
Well, that might be.
Why
I
doesn't
don't know what
Section 27D only apply in cases where the complaint was filed by the person seeking the waiver of the fees?
Correct. That's my question.
Your Honors, there's two reasons. First, Section 27D, by its terms, states that it applies in any case where the denies request for a waiver.
Yeah, but don't you have to read it in context with the section that says, 27C, which talks about initiating or bringing a complaint, bringing an action in a court of the Commonwealth?
Yeah, but look at 27B, which talks about after commencing an appeal in any court.
Yes, Your Honors, I would urge the Court to look at the statute as a whole in terms of how the statute walks a party wishing to file for a request for a waiver of costs through the statute. Section 27A is simply definitional provisions, so it dictates to whom the statute applies, and includes in 27A that it applies specifically.
No, I understand all of that. The difficulty that I have is that 27D was it's a 2004 statute. And one has to look at what the legislature is trying to do. I understand that 27B talks about or appeal in any court, but it seems to me that I'm having a really difficult time seeing why you're going to push all of these appeals into the statute within 7 days.
And, Your Honor, reading the statute as a whole, it is our submission that 27B dictates the terms to whom the statute applies. That's the initial part of the action that the Court must look to. It starts with 27B, and it specifically states that it applies on appeals. The next step is go to 27C, which provides what procedures apply. What does the Court actually do when it receives that request for a waiver?
Do you happen to know, Mr. Hallas, we've had informa pauperis, proceedings in criminal, just straight-out criminal cases. Do you know of any case where we have not permitted somebody to proceed because they didn't file a challenge to a denial of an informa pauperis within 7 days?
Your Honor, no, I'm not familiar
So
with
let's assume
criminal.
let's assume that there's an informa pauperis proceeding, and especially in the last few years, judges have been taking a pretty close look at the assets of people who claim to be informa pauperis, and their determinations that they can't proceed informa pauperis, and you're telling me that if it turned out they wanted to appeal that and they hadn't done it within 7 days and couldn't continue their appeal, that we would say they were barred from an appeal?
Yes, Your Honor, precisely, because in that section, Chapter 261 does not apply.
Doesn't that run straight into the United States Supreme Court's jurisprudence? That somebody who has been convicted as a criminal defendant is barred from proceeding with the appeal because of a state statute?
Your Honor, the criminal defendant would not face Chapter 261, so there wouldn't be a statutory bar.
Why?
Because there are no fees and costs to be waived pursuant to the procedures in Section 261.
But there are.
It's only because
we
of the
waive them
rule.
as a matter of course.
Your Honors, again, I would urge that this statute doesn't provide that there must be fees and costs. It simply provides that where there are fees and costs and someone is an inmate, they have to follow a particular procedure.
No, but it could be a criminal case.
Yes, Your Honor. In that case, there are no fees and costs, so there's no need to go through this procedure. However, where there are fees and costs, and someone is an inmate,
there may not be fees and costs, but there are costs of expert opinions, or somebody files an informa pauperis, and as Justice Botsford alluded to, the defendant happens to be somebody who, let's say, the judge has reason to suspect is not lacking in assets, and so they have, the judge says, I'm going to deny the informal pauperous, and then at some point he doesn't file or she doesn't file within 7 days, and you're telling me that they can be barred because they didn't do it within 7 days?
Your Honor, are you speaking again about the criminal context?
Yes.
And again, Your Honor, I would urge that this simply would not be before the court because criminal defendants would not need to file this procedure because there is not a $300 filing fee the same way that there is
But there
for
may be
civil.
other fees and costs. I mean, you can't then say, well, I'm just going to cut this little bit off, right?
Well, Your Honor, and I would respectfully submit that's what's at issue right now before the court, that the respondent only has standing to challenge on a constitutional basis what is before the court, and that is his status as a non-indigent, sexually dangerous person who could afford the fee but does not wish to pay the fee.
I have not done any, but I'm asking, I'm looking at when 27D was first added, and then what we're looking at, the copy that's in your addendum is from 2004. Do you know when this 7-day period of appeal was put into the statute?
No, Your Honor, not off the top of my head.
I think, well, maybe I'm wrong, but I think it was recent, but maybe I'm wrong.
Is a short answer to this case, without all this thing about the 7 days and all this other rigmarole, which may be important, but isn't the short answer, could be a short answer, that this fellow had $1,700 in his account. The fee is $300, as I understand it. His expenses are all taken care of because he's an inmate. Therefore, he has enough assets to pay the fee.
Yes, Your Honor. And I would agree completely. And turning to the constitutional argument.
Well, can I just place you on that? Let's assume we still have to, whether or not that constitutes whether or not he constitutes somebody who's eligible for a fee waiver, isn't the issue here how he gets that decided? It may well be ultimately on the merits. Somebody says, well, for an inmate who has, as Justice Glaney suggests, all of his things taken care of, $1,700, where somebody who, is not incarcerated and has to pay for rent and so on, you would make a substantive. But the question is, let's assume that the inmate wants to challenge whether, in fact, he can have the benefits of an informal pauperous rule. Isn't the issue how he does that?
And, Your Honor, I would submit that issue is not before the court because the respondent never raised that issue with the single justice. He never has argued that Justice Duffley's decision was incorrect in the sense that Justice Duffley incorrectly calculated the fee. And, in fact, before Justice Duffley, he didn't make any statutory or constitutional arguments. Therefore, an argument such as that would be waived. It would not be before the court.
Now, that's what I'm saying. And in a sense, we have to decide whether he could.
Additionally, Your Honor, constitutionally speaking, he would not be able to bring those arguments because he would not have standing to bring those arguments. And as the case law makes clear, if someone is not indigent, they cannot then challenge a statute constitutionally on the basis of indigency.
Wouldn't he, at the very least, if he wanted to say the $1,700 makes me, I'm still indigent, have to have a specific showing of why, where was the $1,700 going? What's he going to pay it for, or what he has to pay it for? Just like someone, in the civil context who's trying to get the fees waived, or some other context, has to fill out an item-by-item form on rent and debts and all that kind of stuff. And he didn't do that here. He just got an argument, well, I got $1,700, and, we can use that for certain things down at the prison. That's not good enough, is it?
No, Your Honor, I would agree completely. And the only argument that's in the record is the respondent's statement in his affidavit, I am indigent. He also submits his inmate transaction report, but he does not then argue
Why can't
for
we
that.
decide the whole appeal on this basis? Why do we?
It fits within 27A-B, I would suggest. I mean, he is indigent, isn't he? He is a person whose income after taxes is 125% or less of the current poverty threshold, isn't he?
Yes, Your Honor.
He would be, according to our statute, indigent.
Not according to the statute, Your Honor, because he is an inmate. And
Well, that's right. If Section 29 applies to
29
this kind of
applies.
action, then you're right.
Right, but if it doesn't, then you're not right.
well, the definition of inmate is actually contained, Your Honors, in Section 27A. rather than 29.
Yes, but 27 itself after A doesn't use the word inmate ever. It just talks about a party.
Your Honor, I'm not familiar enough to be able to say one way or another if that's true. However, I would state that when a party is an inmate, a special procedure applies, and not the procedures that would be found under the normal procedure found in indigency, for the very reason that...
But what we have is very clear, it seems, and again, I don't want to just repeat it, it seems to me that there's a very clear theory about how what all of this is about for purposes of inmates. One is, people who are appealing some, at minimum, criminal sentence, and then you get into whether or not, if you get an order incarcerating you for, potentially for the remainder of your life, that falls into that category, as opposed to inmates who are engaged in not civil proceedings, but proceedings especially where they are commencing litigation.
Well, Your Honors, it would be our submission that the legislature has included them, and the Court needs to defer to the legislature's classification as long as it is not unreasonable. And here that classification is not unreasonable for several reasons. First, the respondent is an inmate. Therefore, most of his costs are taken care of by the state. He has this money to pay the fee in his account. Second, the respondent is a sexually dangerous person, and therefore has many more opportunities for appeal and direct review on appeal than would a criminal defendant.
Okay. Thank you, Mr. Hallett.
Thank you, Your Honors.